record does support what the defense argues, which is that this matter was, from the court's perspective at least, fully litigated. And so I'm going to start with Ms. Gibbs. This is the state's motion, unless it's Mr. Shepard.
No, Your Honor, it's the state's motion.
As to why we need to relitigate this issue.
Yes, Your Honor. Your Honor, the state, while I more conventionally would start with the motion, I wanted to, before we begin, I know Your Honor has had this case for now going on 2 years, and in addition to looking through and seeing any motions or anything that's relevant for us to have for the trial, the state has also been in contact with the parole board at every step of the way, because we know that in addition to wanting to make sure we're ready for trial, the reality is that the state has continued to present options for a plea negotiation. And I just wanted to place on the record before this motion, on the record the plea, and then while we go through the motion, we'll get counsel and his client, we'll get time to discuss this, but it needs to be apparently abundantly clear that today, this offer that the state's placing on the record is the final offer. We cannot keep coming back here talking about certain negotiations, and really the state wants to put forth the best offer, frankly, that they can possibly do. And then, Your Honor, I will respond to the motion, the court's question in regards to the law of the case. Here, Your Honor, the state offer was a second-degree reckless manslaughter. The range of second degree obviously is 5 to 10, and the offer was a 10.85, Your Honor. The defendant at this time, based on the parole board representative, indicated that Mr. Puskas has over 9.5 years in custody at this point. He will have 10 years on February 15th of 2024. That would mean that he's already served a year over 85% that would be associated with the top max sentence. One of the concerns that defense mentioned when we were last here was defendant's parole supervision period of 3 years that he would have with that second degree sentence. And upon discussing this with the parole board representative, it was determined that based on the fact that Mr. Puskas has done more time than he would have had to do on the max sentence for a second degree offense, that additional time that he's been in could be used to reduce his parole supervision period, because the way that the DOC sees it and parole sees it is, even if the defendant is released while he's still under the supervision of the DOC, if he's in custody, he's still under the provisions of the custody of the DOC. Both of them would be applicable. Therefore, his additional time that he's been in custody would go to reduce the parole supervision period. And I place that on the record to say, Your Honor, that would be if he pled to the max of the second degree. Defense counsel, when we spoke prior, mentioned that if there were ever to be any negotiations, that it would have to be something less than the max, meaning 7 with an 85, let's say, Your Honor, for a mid-range. The reality is, if Mr. Puskas were to plead to a 7 with an 85 to the second degree reckless manslaughter, he would have essentially not only done the entire time for the 85%, but he would have also done the entire remaining time that would have been to reduce his parole supervision, and his parole supervision would have been complete in August of 2023, specifically from the representative in parole. They stated August 5th of 2023, he would have completed not only the 85%, but based on the additional credit, he would have also reduced his parole supervision period of 3 years to the point where he would have been released in August. That is being placed on the record to say, Your Honor, if the defendant were to respond with any counter in the second degree range, any counter at all, the state would be willing to take it back to the prosecutor, but again, any counter would have him at a point where he would not only have served the entire time of the sentence, but also the parole supervision period. And at that point, he would not have any supervision upon release after the sentence. So I printed out the information, Your Honor, that the DOC, the parole board, provided to the state. I've provided that to counsel. I can provide it to the court as well, but either way, it is for, at this point, while we go through the motion, I wanted that to be very clear, because after today, the deal can't get better than that. There's no other, we're at where we're at, and at that point, we would have to move forward to trial, and that's fine. But at this point, it would not be another time. We would not prepare for trial. We would not have witnesses lined up to give this offer at a later date. counsel wanted to speak to the parole board. He doesn't have to take the state's word for it, obviously. I'm an officer of the court, but we have an individual lined up at 10 o'clock for counsel to speak with his client. If he wanted to actually speak to them and receive this information from them verbatim. But either way, Your Honor, this was in preparation for today to ensure that while we're also litigating and moving for a trial, we're also openly trying to determine what possible plea could help with closure for a case. And again, if we want a guilty plea for someone who's guilty, we don't want these numbers and anything that's being placed on the record to persuade anyone who did not do something. If someone's innocent, we go to trial. But if the defendant is guilty, what the state is asking for is a guilty plea to what happened, and in return for that, we will be able to negotiate a plea where he basically will serve not only the sentence, but the parole supervision period as well.
Did you want to respond?
No, ma'am.
Okay. Come with a motion.
Thank you, Your Honor. And now, in regards to the law of the case, Your Honor, you bring up an excellent point. Counsel did provide to the state a submission, and I have a binder here that basically includes, I'd say, basically almost 200 pages of a response in regards to, I would say that it was said that this is a decision, a thorough decision by the previous court. That raises a lot of concern to the state because when the state thinks of a thorough decision, it doesn't take 200 pages of a transcript. 200 pages of a transcript is a trial. And the concern here is when I have a transcript that's from December 1st, December 2nd, December 6th, December 15th of 2016, a transcript that is in between a trial with different witnesses testifying, it makes it almost the opposite of it being thorough. It is clear that this decision in this case was done on multiple days through multiple people without a clear witness called by the defense as to what he was trying to elicit in regards to the reverse 404B. When we talk about thorough, this is exactly what the appellate division discussed, the fact that what findings, where can counsel point to a finding that was clearly laid out so that the state and defense clearly know what's admissible and what's not. That wasn't done here. What it appears is that during the trial, something came out that defense counsel felt was relevant to third-party guilt, and they continued to discuss this, and then at some point in these 200 pages, Judge Nieves, or the prior court, made a decision about particular evidence that, again, I don't even know what it's supported upon. I don't even know the basis for it. When I look at the submission from the November 7, 2013 home invasion, there are so many inaccuracies as to what was stated happened, but what all 5 of the individuals involved said, it's not possible that the prior court had the right information. And let me be much more specific. One, from all my understanding of this home invasion, everyone stated that this had something to do with some kind of drug deal gone wrong, that these kids were somehow selling drugs out this house, and that Billy was a roommate at this house, and that at some point somebody came here to take drugs or take money. Couldn't be further from the truth, Your Honor. Defense counsel's letter states that Billy's roommates. Billy wasn't living at 91 Easton Avenue. He didn't live there. 4 kids lived there, and Billy was visiting. It's clear from the transcripts, when Billy is asked, where do you live? He says, I don't live here. That's in the transcript. In addition to that, the other roommates indicate Billy didn't live there, that Billy was just visiting and he was a friend. Furthermore, the target, the person who actually got pulled into the room, was an individual named Matthew. Matthew lived there, and Matthew made it very clear the money that he gave to the suspects came from PSC&G bills and rents. When asked by the officers, did it have anything to do with drugs? Did this have anything to do with any narcotics? He said no. He said he doesn't sell drugs, and the only thing he has to do with drugs is that he smokes a little bit of weed. But again, had nothing to do with selling drugs. The proceeds never came from drugs, and more specifically, he specified where it came from.
So did the state during the course of the trial have the opportunity then to ask and to challenge that, the defense's theory as it relates to third-party guilt? Was there that opportunity?
That's a great question, Your Honor. Apparently, during the first trial, it appears that this all came out as the witness was on the stand during the trial. Therefore, the state, unfortunately, was catching up to getting the reports from this November 7th incident and trying to gather the information while in trial for the underlying offense. So it appears from the record that the state was catching up right along with the defense in regards regards to the depth and the specific facts of the November 7th,
Isn't that a
2015
trial?
incident. I'm sorry?
Isn't that a trial sometimes then?
It was absolutely a trial here.
So do you think the jury potentially rejected what was the theory that of some third-party guilt by way of the verdict?
I absolutely think they did, and that's, I think, the state's point, that the information here is absolutely a waste of time and a confusion for the jury. It is not relevant that Billy, 3 months before his murder, was at a friend's house, and those friends had a home invasion that resulted in PSE&G and rent money being taken. That incident is unfortunate that happened to Billy, but to this record that we have, there is no connection of that event in any way to the incident that happened to Billy on February 15, 2014. That's the state's point. There's no nexus. There's no connection except that Billy was involved in one and Billy was involved in the other. And based on the case law, defense counsel needs more than that. It cannot just be that there is some possibility or speculation that something happened. Third-party guilt has to be stronger than that. And that's why we do the motion in a pre-trial motion set instead of a trial set. Because I do believe in the first trial, in an effort to say it's third-party guilt, and we say that, and we think that just triggers that everything in the kitchen sink comes in. The reality is that once it's thoroughly fleshed out in a pre-trial motion, not in the middle of a trial when the jury is standing downstairs waiting to come up, you have time to really sift through and see, is this relevant? Is this a waste of time? Is it going to violate Rule 403? Why are we talking about Billy being kicked in the head at a home invasion when the reality is another kid was kicked in the head as well? It is clear that Billy wasn't the only person kicked. He just didn't block it. But again, why are we talking about that when we're not talking about the homicide, the reason why we're here? I believe it is a waste of time to bring this up. And frankly, I don't believe we can say it's a third-party guilt when we have no other facts about how this would relate to our incident. And I want to be clear, when we talk about counsel saying that this was a violent robbery that involved Billy and drugs, again, it's not accurate. We have here Billy being kicked and punched. He refused medical attention. He refused it not only at the scene when he was there, he also refused it when the officer asked him at his statement, do you need medical attention? Are you okay? Refused it. This wasn't a violent attack that resulted in some, based on a drug deal. We also have counsel stating in his papers that the getaway car was by a James Smith, which was a friend of Billy. Couldn't be more inaccurate. It states clearly in the incident report the car that the suspect used to get away was issued to a woman that lived in Linden, New Jersey, who had no connection at all to Billy, at all, zero. So again, the facts here, if they were clearly laid out in a setting like we are in today, would give a court the opportunity to understand that there is no nexus to Billy and this home invasion. The home invasion was at a friend's house who has nothing to do with this particular case. And I believe that while the prior court did rule for it to be admissible, the fact that in addition to jury rejecting it, further states that it is irrelevant and it should not be admissible in the second trial unless counsel can state a witness that he is going to bring in, that he is going to bring this information in through, and clearly document what information gives it a nexus that there's third-party guilt to this particular incident that happened on February 15, 2014. The state shouldn't have to do this. This is not our evidence. We're not trying to bring in bad acts to the victim. Counsel is. So if counsel is doing it just like the state has to under 404B, bring your witness in. Have your witness explain how Billy's drug dealing or how Billy's Adderall pill or how Billy's going to this house has some nexus to a third-party guilt of something that happens 3 months later. That hasn't been done here. So at this point, Your Honor, the state believes that it is frankly premature to even allow the information to come in until counsel can outline what witness is going to testify, what witness is going to testify to, and then we can really intelligently discuss whether or not the information should get in. And I don't believe that the law of the case has covered any of that, Your Honor. So with that, I seem to defer whatever questions you have.
So you say Judge Nevis got it wrong?
No, Your Honor. I'm saying that the court didn't have the opportunity to even explore it in a meaningful manner when you have a jury sitting downstairs. So in an effort, when you hear his third-party guilt, in an effort to move that trial along, he continued to let the testimony in because he was not provided the opportunity in a setting like this to have a organized a logical submission, to have the opportunity to make a clear decision without a jury sitting down just ready to come up. So I don't think he got it wrong. I think it was not done properly. It should have been done pre-trial motions.
Judge, I assume, I know it's a lot of stuff that we cited to, it's a lot of pages, so I assume you had an opportunity to
Have no
look
fear.
at it.
I always do my
So,
homework.
the state misstates a lot of facts. Just a little bit of a this is a law of the case issue. This was thoroughly litigated and a decision was made by allowing the evidence in. The state stands up here and makes certain statements that are just not accurate and they're not true. The evidence, when it came in, it can come in through any competent witness, whether they're called by the state or called by the defense. A bit of a backdrop as to what happened in the prior trial, Judge, and in the prior handling of this case. There was a lot of information that would be deemed either Giglio or Brady information that the state withheld, that the defense actually found through the defense investigation, and that was not turned over by the state. That was a thread throughout the entire trial. One of those instances is the discovery from this robbery. There were others, if you recall, the dog that we found, the letters from the attorney who was cooperating, their witness. Those are all things that the defense found, and they resulted in a charge, in a jury charge, violation of Brady that was given to the jury in this case. I say that because the state wants you to believe that this happened as a surprise or it happened during the trial. It couldn't happen at a pretrial hearing because the state withheld the information. Notwithstanding that issue, Judge, we litigated this issue to death, over the course of several days. And the state just keeps talking about third-party guilt, third-party guilt, third-party guilt. This doesn't just come in for third-party guilt purposes. It comes in to show what the police did or did not do in this investigation. Because obviously our defense is, Mr. Puskas didn't do this. So therefore, since there is a body, somebody else must have done it. And we are entitled to put forth defenses that are relevant to this issue. And why is this relevant? The state just talks about this robbery. It says, oh, this was PSC&G money. Right, Matthew Oftering is going to go into the police station and tell them, hey, yeah, I'm dealing drugs, that's drug money. Nobody does that. He's not going to do that. We know it's drug money, we know there's drug dealing, and we know that Matthew Oftering is partners with William McCall from the text messages that are found in William McCall's phone. Right, so the evidence isn't just this robbery, right? There are different threads of this evidence that come in through different witnesses. One of those witnesses was the phone guy, the guy who went over the phones, their witness. Another witness that we got some evidence from was the lead detective, who investigated some of these things, but the question was, did you investigate them thoroughly? I'm not going to waste your time here. I know you read everything, you know my point. The thing about the car, that doesn't come from me. That a car belonged to James Smith, the getaway car belonged to James Smith. That comes from their discovery, from their lead detective. He's the one who said that car belonged to James Smith. That's where the license plate came back to. I don't know what this lady from Linden is all about. That's news to me. But I didn't make that up. That's from their discovery. And James Smith, which was an important character in this particular drug dealing enterprise that Mr. McCall was involved in, because he was his roommate, in our text messages between him, James Smith, Matthew Oftering, and all these guys about, a quarter pound of weed, Adderall pills, whether they were selling it for profit or sharing it amongst each other or whatever it is that the state wants to believe, there was drug dealing activity between all these people. And this robbery did not happen to be some, we're just going to go to this kid's house to just rob him for PSC&G money. The jury can reject or can accept the theory, Judge. Obviously, they rejected it in this case in the first trial, but that doesn't mean we're not entitled to put forth our defenses. This was thoroughly litigated. And unless the court has any additional questions, I just don't, there's nothing else I need to say. It's all there.
have had the opportunity to read your submissions in this case, and as was pointed out, I've had this case for some time now, following the appellate division's reversal of the defendant's conviction, and having read your papers and understanding your arguments as they have been presented, not only through your very thorough submissions, but from the court's review, it appears to me that this is a matter that was litigated, and so to the extent that while it may not have been happening in a manner in which we sometimes conventionally see these types of applications, trials are such that things are often happening on the fly. And so I'm satisfied, based on this court's review of the record, that this is an issue that has been litigated, and I don't have a basis at this time to second guess why Judge Nieves allowed this evidence in. There's nothing that sticks out to this court as clearly erroneous, and so not only is this evidence from which the jury should be able to consider whether or not a third party may have committed this homicide, but whether in fact there were other avenues that the investigators could have explored in investigating who ultimately perpetrated this crime. And so it is the court's decision that the motion to preclude the evidence is going to be denied. I have prepared already a statement of reasons. I would like to tweak it a little bit in light of some of the arguments that I heard here today, but nothing really changes in terms of the court's analysis and perspective as I see it. So for these reasons, the application is denied. I'm going to upload an order along with my statement of reasons. I am instructed to have you go with Judge Flynn to address scheduling.
Thank you very much, Robert.